Entitled to hear a case, a court of original jurisdiction. And the one I'm going to spend some time with today is legislative jurisdiction, because I think that all of the other jurisdictions are contingent upon the legislative jurisdiction aspect. And this is probably one of the most misunderstood of all the jurisdictions, because when we get into legislative jurisdictions, we're not inside of a court. Plenary jurisdiction means a court can do just about anything, or a state can do anything. Plenary means just be with no boundaries. Now, jurisdiction itself is the power and authority constitutionally conferred on or constitutionally recognized as existing in a court or judge to pronounce the sentence of the law. That's the dictionary definition of jurisdiction, right out of Black's Law. Upon a state of facts, proved or admitted, referred to the tribunal for decision and authorized by law to be the subject of an investigation. Bottom line, jurisdiction is the power and authority constitutionally conferred on a court or judge to pronounce the sentence of the law. Now, this would be, of course, judicial. Common law jurisdiction is the jurisdiction of a court to try and decide cases as were cognizable by the courts of law under the English common law. The jurisdiction of these courts which exercise their judicial powers according to the course of the common law. There's a little bit of a misunderstanding I've experienced in this country as to what common law is. In Colorado, the common law was adopted as initially part of Colorado's law. When a statute comes along and codifies what was otherwise written in common law, the common law ceases to govern in that area. The statute takes over from there. So common law exists up until the time a statute is created, at which time the statute takes over that area of law. So like in the Kevorkian case, there was no specific jurisdiction from a statute that authorized them to bring the charge, so they resorted to the common law. The Constitution is a common law instrument. It was written from a common law jurisdiction. The remedy, I think, in our present day situation is to look back to the common law, to learn from it, and learn how to apply it within the structure that we've been given to operate. So when we go into jurisdiction, I want to talk about legislative jurisdiction, concurrent jurisdiction, and proprietary interest. In the case of the United States versus Colorado, actually the United States versus the several states, in 1956, excuse me, the Eisenhower ordered a study. He wanted to know about all of the land holdings, all of the interests that the United States had in all of 50 states. And so he ordered a report to be done. And in this report, they compiled all of the federal areas within the states. And in these two reports, it talks about where the jurisdiction of the federal government lies in the states. And they came up with these three kinds of jurisdiction. Either the federal government has legislative jurisdiction, which means that they have the power to make all law in that particular area. So if a state is exercising legislative jurisdiction within a federal enclave, that would be a usurpation of federal jurisdiction. The state's jurisdiction ends at the boundaries where the federal jurisdiction begins. There's a line of demarcation there. Were you successful?
No, we didn't have enough money.
Oh, okay, never mind that. We'll bear with it. 20 bucks wasn't enough. Okay. So this committee determined that these are the three types of interests, jurisdictional interests that the federal government has. And we'll just use state of Colorado because this is where we live. Legislative jurisdiction would be over, say, post offices, anywhere where the state of Colorado has ceded its legislative jurisdiction to the federal government. And basically that federal government island. It is literally an island within Colorado. That island, where the federal government has legislative jurisdiction, is no longer in the state of Colorado, even though the land's right there. It's in another jurisdiction. Now, see, this is a mental thing that we have to get our mind around. Jurisdiction exists by a boundary that you can't see, smell, taste, touch, or feel. The 10 square mile District of Columbia is a federal enclave, and the United States government has exclusive legislative jurisdiction over that 10 square mile district. Puerto Rico, Guam, Mariana Islands, Virgin Islands, all those are islands of exclusive legislative jurisdiction. And I'm going to come back to this later and show you here in Colorado where that lives, or how we can distinguish those things.
I got a question for you.
Yes, sir.
Real quick. We just had a meeting earlier this week with the commissioner, and one of the discussions was by taking federal grant dollars in these application processes, there's all these complies. You must comply with all these federal rules. How do you get away from jurisdiction, or are we beholden to that on a local level when we take these dollars and then have to comply with all these federal
Mandates?
Correct.
Let's come back to that. Let's start with this, and then we'll get there. This is a foundational, and if there has been an abuse or usurpation, we have to start with the premise that originally there is a distinction between the state and federal government, and if by virtue of a contract or a compact that has been wiped out, then we'll deal with that. But for right now, let's just lay some foundational. Okay, so one place where you can really see the effect of jurisdiction is in Article 10 to the Constitution for the United States. All power not delegated to the United States or prohibited by it to the states is reserved to the states respectively or to the people. That's the 10th Amendment. And this is distinguishing the power not delegated. Now, by virtue of the fact that it's not delegated, wouldn't that imply that all of the other power is delegated? And notice if power is delegated, that there's a source from which it is delegated. So the United States Congress, or the United States, exists by power delegated to it. The Constitution also acts to prohibit powers to the states, and by virtue of those, any power not delegated or prohibited is reserved to the states respectively or to the people. So notice in this particular amendment, the people are listed as having a residual bit of power in them. How much is left? Well, let's start from the beginning. The preamble to the Bill of Rights, and this is something I push hard, I don't like the term Bill of Rights. I don't like the term constitutional rights. If we approach this from the preamble of the so-called Bill of Rights, it specifically says the conventions of a number of the states having at the time of their adopting the Constitution expressed a desire, and why? In order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. The so-called Bill of Rights is technically a Bill of Limitations. In other words, the power was delegated by the Constitution, and the so-called Bill of Rights comes along and says, oh, by the way, while you're exercising your power, here are some things you will not do. And those first 10 articles in amendment are the thou shalt nots. Those are the thou shalt not. While you have this power, while you're exercising this power, you will not enter into somebody's home without a search warrant, supported by probable cause and an affidavit reduced to writing. You will not infringe on the people's right to keep and bear arms. You know, those aren't the sources of rights. Those are announcements of limitations on the power of government. And when you get into the system, which a lot of us don't know because we're not criminals. The criminals find these things out. The lawyers know these things. They're the ones that get into court They're the ones that get the Constitution applied to their cases because the government, in overstepping its boundaries, the lawyers can use those oversteps to get rid of evidence that was illegally obtained, maybe through an unlawful warrant or an illegal arrest or an unlawful search. So they're applied as restrictions on the power of government. So the 10th Amendment is just an announcement. Hey, by the way, any power not delegated is reserved to the people. What kind of power is reserved to the people? And one of the most primary powers that's reserved to the people is the right to alter or abolish a government that ceases to function to the end it was established to secure. That's a power that is reserved to the people.
Right.
It was not delegated because you can't delegate that because that's a power inherent in the people. The Declaration of Independence is very specific that to secure these rights, which ones? The ones that were endowed on us by the Creator, according to the Declaration of Independence. Life, liberty, and the pursuit of happiness, among which, there's a lot more. The 10 articles and amendment don't announce all of our rights, they announce these limitations. The 9th Amendment says that the enumeration of certain rights in the Constitution shall not be construed to deny or disparage others retained by the people. So there's a whole litany of rights that are actually limitations. The rights are limitations. Our rights are their limitations. And here, going back to Colorado, all political power is vested in and derived from the people. All government of right originates from the people, is founded upon their will only, and instituted solely for the good of the whole. Again, the people of this state have the sole and exclusive right of governing themselves as a free, sovereign, and independent state, to alter and abolish their constitution and form of government whenever they may deem it necessary to their safety and happiness, provided such change is not repugnant to the Constitution of the United States. These are powers reserved to the people. The whole point, I believe, of the First Amendment is to protect this kind of speech. When the government becomes destructive to the end it was established to secure, when a long train of abuses and usurpations, pursuing invariably an object, evinces a design to reduce the people under absolute despotism, I can stand up here and talk about it and not worry about the KGB or the Gestapo running in here, putting a black bag over my head and hauling me off because I had the audacity to speak against the corrupt governmental system that has so abused its power that is attempting to reduce us under absolute despotism. That is a unique feature in American jurisprudence and is what makes America special in the world, because the people have that protection to speak out against the government without fear of retaliation. Not that it won't happen, but we certainly have it here. And that's what we're fighting for. We're fighting to protect these principles, and this Cloward Piven strategy is fighting to destroy these principles, and that's an act of treason. And I'm going to call it exactly what it is. What we're seeing in our government today is an act of treason against the American people, who are the sovereign in this country.
People.
There's a coup d'etat happening. They're using the law itself as an instrument to create the chaos that they then will capitalize on once their New Deal is complete. And if you study the history of socialism and governments that fall from within, this is typically the means to that end. Let's learn from history this time and stand on the principles the Founding Fathers gave us and use the law and use the courts in a productive fashion, and find a few judges that have a heart that's not so calloused. Give them an argument that they can hear and rule on. And let's get the people behind them, and let's bring this thing to a head inside the system if we can, before we ever think about going violent. Because if we go violent trying to defend this thing, we will give the Cloward Pittman people exactly what they need to justify maintaining a moral high ground and finishing the work that they've started. So what is the Colorado Enabling Act? The Enabling Act, of course, Congress in 1875 issued an act, which, by the way, is the supreme law of the land, entitling the people of the territory of Colorado to join the Union on an equal footing with the other states. In the process of doing this, Colorado became a sovereign state. Right there. This is Article 2, Section 2 of the Colorado Constitution. excuse me. When we're exercising our power, we have to start as individuals, and we have to understand that if we're thinking in terms of just the United States Constitution, just the United States Constitution, just the United States, just the Pledge of Allegiance, we're missing a very key element in the area of jurisdiction. Colorado is a sovereign state. And if the governor and the state legislators do not understand that, they need to be educated. Colorado's a sovereign state. Now, through subsidies and grants and contracts and interstate compacts, if that sovereignty has been compromised, when the state of Colorado didn't have the authority to enter into those compacts, except through fraud or treason, then I ask whether those contracts are really valid. And when the monetary system that we're using is really all script and it's not based in a constitutional money, are these obligations valid? There's a lot of questions about some very unscrupulous things that have happened in American history that need to be looked at through the eyes of the Declaration of Independence and through the eyes of the law in order to discern or distinguish whether these acts be valid or not. And so in order to distinguish that, again, we have to go to the fundamentals of law, again, which jurisdiction is one. So here in the Colorado Enabling Act, it says here that the people of Colorado are authorized to adopt the Constitution, or hang on, to have a convention, and they're authorized to form a constitution and state government for the territory, provided that the Constitution shall be Republican in form and make no distinction in civil or political rights and on race or color, except Indians not taxed, and not be repugnant to the Constitution of the United States and the principles of the Declaration of Independence. Principles. Not the words, the principles. You can't touch principles. So the principles of the Declaration of Independence are built right into the system of law in Colorado. If you go to Book 1 of the Colorado Revised Statutes, this is Colorado law, and the very first thing you run into after you get through the Roman small numerals is the Declaration of Independence, okay? Article or page 3. Declaration of Independence is the foundation of law in Colorado. So those people that get a little squeamish about the fact that the people have the right to alter or abolish their constitution and form of government, they need to go and get an education and learn that the reason for government is to serve the people. But we are now living in an age where the government thinks that the reason for government is for the people to serve it. And if you look at the taxes and the Department of Revenue and the entire system as it's set up, it's hurting the people under an absolute despotic regime. A design has in fact been evinced. But how did they get there? But through the usurpations and abuses of power. If they had just come in with guns, and we wouldn't have accepted it, but they used the law. Some very unscrupulous people, used the engines of the legislature and the courts and the executive powers to instrument and orchestrate this finale where we're being forced to accept, under threat of jail or threat of, whatever, to accept a principle that is completely contrary to this, principles of the Declaration of Independence, and a guy like me standing up here saying these things is considered radical. Just the fact that that would be entertained in our thoughts in itself is evidence that something's real wrong. When anybody that would champion the fundamental principles would be considered a radical. And this is in a derogatory sense. Not a radical in the sense of fairness and going back to the root of things, but a radical in the sense of, he's an extremist. Well, in a relative sense, if someone's defending the